I'm Sheba Varghese, Assistant Professor, Law, Azhar Law College. I'm very glad to welcome you all to the second day and second session of the International Faculty Development Program titled Legal Research and Pedagogy in Changing Era. I know you are eagerly waiting for the second session that is going to be carried out by Dr. Jasmine Alex, Assistant Professor.
She got the Special Jury Award for the Peace and Endowment instituted by the Indian Law Institute Kerala chapter for her immense contributions. She was a resource person for the national seminar sponsored by the UGC for the Arts and Science Colleges in Kerala during 2005 and 6. She has a great personality and was delegated by MG University to represent it in the Net Review Committee of UGC at Hyderabad. On behalf of AALC Law College, I welcome Jasmine Madam to this session.
Thank you very much. Shall we start with the session?
Yes, ma'am.
Yes, ma'am.
Okay, good morning, all of you. And I'm very much thankful to the principal and the coordinators of this faculty development program. I hope this may be a meeting for all of us to share the ideas relating to an effective research. And let me share my screen.
Yes, ma'am. Yes, ma'am.
Okay. So let us begin with a question. What is research? Okay, we know that research is something which is inherent in the you look at a child when he starts seeing something, he will ask what it is, and when he start walking and see the queries, the anxieties of a baby, that is the inherent expression of the basic quest for information or knowledge. And when we grow up, we'll be able to conduct inquiries of our own. Suppose we start learning a new language, say for example German, and start reading a book in German, and when you miss the meaning of certain terms, you look into a dictionary. That's a kind of research. And if you are interested in sociology and you are about to study the influence of family in the personality development of a child, then you will go for instances, then you'll go for inquiries and will try to get information from various groups, children, parents, teachers. So that's a kind of research. To be precise, research is something which is inherent. The quest for research, the quest for information is something which is inherent in the very life of a human being, in the very personality of a human being. To be precise, or academically speaking, the investigations, inquiries, or probes in any particular area of discipline can be considered as a research for academic purposes. Or in other words, it's a careful and detailed study of a topic to collect more and more information of that area. It may result in adding, deleting, updating, separating, correcting the previous existing knowledge, and may result in a new set of or a new framework of information. And this is the summative meaning or concept of research. And when coming to legal research, we know the very importance, very relevance of research in the area of law. A lawyer, a practicing lawyer is a researcher. Whenever each and every factual situation comes before him, he has to look for the relevant law, the previous judgments, or even to find out the gaps to be filled by interpretations or applying international principles or concepts of human rights, etc. Then again, let us see the picture of or the plight of a judge. While rendering a judgment or a decision, he has to do a lot of background research work. And for an academician, for his routine teaching, even for that routine teaching, he has to do a lot of research. And for a law student at whatever level, at graduate level or a postgraduate level, or even for a researcher. But now let us specifically or precisely try to understand legal research addressed to academicians and research scholars. And let us see the purpose of legal research in this context. For a legal researcher or a research scholar or an academic lawyer, the very purpose of his legal research is to find out the lacunae in law. And because of his research, he may be able to provide the excess set rules or laws in a systematic and comprehensive manner. He also may be able to provide expanded meaning and scope by interpretation. And moreover, this research work, legal research, is in fact a search into the needs of the society. Again, he can ascertain what the law is, the law which may be relevant or which can be applied in a particular situation. Because of his research, or as a result of his research, the ambiguities in law may be clear. The research work, the investigations may help the researcher to identify the weak points in a specific direction. He will be able to critically examine the order to ensure consistency, coherence, and stability in law. The best result of a research, impact of a research, is that the researcher may be able to predict future. This may happen when he provides a legal framework or a new form of statute or a skeleton for a new statute, or certain suggestions to be adopted, to be incorporated into a new law which is proposed by the researcher, etc., etc. Scientifically speaking, let us divide legal research into different categories. Frankly speaking, it's not necessary that we have to understand what it is, even understand what it is, but better to know the nomenclature which is used to identify different types of research, that is fundamental legal research, descriptive legal research, analytical legal research, applied legal research, quantitative legal research, qualitative legal research, etc., etc. So the nomenclature is based on the methodology with which you are conducting the research, or the nature of your work, the purpose of your research. I'll again explain. The fundamental or primary legal research is concerned with the generalization and formulation of the theory. So you are searching for the very fundamental concepts. This is merely for the purpose of increasing the knowledge in a field of inquiry. in the beginning of your research work, or even when you are about to find out a research area, the research may be identified or may be termed as fundamental or primary legal research. Then comes to descriptive legal research. This is an expansion of the primary legal research. And this indicates the phenomenon or a situation under study and its various characteristics. An expanded learning, or you're trying to understand what has happened or what is happening presently. And it does not try to find out the causes of the phenomena or causes of the happenings. Rather, it seeks to describe the study as it is at present. And analytical legal research, it indicates the use of already available facts and information to critically study the situation. Suppose a new event comes to you. I think you may be familiar with the situation in baby Manji's case. A child born out of surrogacy agreement was left or was abandoned by its parents, supposed to be parents, because of their separation. Then the child fell in a situation, in a miserable situation, that the surrogate mother didn't take care of it, because by virtue of the terms of the agreement, the prospective parents had to take care of it. And in such a situation, the court, the Supreme Court of India, had to analyze what all legal principles can be applied to protect the best interests of the baby. So that's simply an example. It analyzes the whole range of facts and information critically, and doctrinal legal research, that is to develop or reinterpret the existing concept of laws. And when it comes to empirical legal research, it involves experiments, observations, field work, data study, etc. It uses facts and data to prove or to establish its hypothesis. Then quantitative legal research involves measurements, quantities, or amounts. A systematic and scientific investigation is identified as a quantitative legal research. So, say for example, you are about to propose certain law reforms regarding prison administration. You may have a hypothesis that the plight of women prisoners in jails are not good. Then you can conduct a survey, conduct interviews, and based on your empirical study, you may quantify your assumptions that 80% of the women in jails are not well protected, their human rights are not adequately taken care of. Okay, this is an example of quantitative legal research. Then qualitative legal research implies that the qualitative phenomenon, that is relating to the quality or characteristics which are involved in the research work. Then coming to the nomenclature of applied legal research, see, that is an ideal kind of legal research. It aims to find the solution from the problems in hand of the researcher. The researcher tries to do his research in a practical context. And also he aims to discover a solution for a pressing practical problem, as happened in the case of baby Manji's case. Okay, these are simply the nomenclatures that will identify the nature and type or characteristic of a research work, whatever it be. We cannot simply say that a research work should be applied legal research only, or qualitative research only, or quantitative research only. It's a compendium of many types. So many features will be involved. And a simple background knowledge regarding all these types of research and the importance of research, the purposes of research, will prompt us to identify a research area. That is the most important aspect as far as a legal researcher is concerned. You know the importance of legal research nowadays, because when a person who is interested to act as a teacher or to join in a university department or a law school, he should possess with a PhD degree. See the UGC, you're familiar with the UGC regulations, and the students are now running after vacancies, research vacancies. So there is a rush nowadays in research centers and departments. And the first question is, how could you identify the research area? And before discussing this aspect, you should understand that research, the quest for research, the taste for research, that is inherent in the personality of an individual. The persons are different. Sometimes certain persons, they are having the capability to mug up, to read and understand certain things. Then there are certain persons, they are capable of simply to apply the principles or the formulations which are provided by certain persons. And a few of the people, they possess the quality, the caliber to do research by their own. They possess the quest for knowledge, the quest for information. And that category of people, they will excel in the area of research. So we can bring up, we can nourish and nurture this quest for information and aptitude of research. And with this understanding, let us see for identifying research or research areas. A person who is always in touch with the knowledge and information in the relevant area will be an ideal person who can enter into the realm of research. Reading or trying to understand the latest judgments, regular reading of judgments, regular reading of journals, law journals, that will help you to identify any research area. So you can always start with the news articles, reading news articles. There you will mostly get reliable information, also the opinions of different jurists. Then try to find out the correct and reliable legal information referring primary sources of law. And I have already told you that reading judgments, that is very much useful, because that will help you to identify the present developments in law, how the legal existing laws, legal provisions are interpreted by the judiciary. Then remember, whatever information you search for and find relevant for yourself, then keep it with you, bookmark it with you. Otherwise, you will always have to go back again and again to find out what you had seen or what you had read in previous days or previous times. Better always keep, when you find something informative or something relevant, or when you find a gap in law, when you find a question or issue, then note it, mark it. See, Mr. Ramanaj Mukherjee has pointed out a working rule that you read 10 minutes, then you spend 10 minutes in writing or noting what you have already read. And again, see, based on your reading or constant touch with the development of law or development of principles or the juristic opinions, you can map out your interests. And it is a must that you have to review literature to identify a research gap. When you are constantly in touch with the literature in a relevant field, you may be able to identify, you shall be able to identify a research gap where you feel a vacuum, that there is no law, no relevant law. that the people, the members of the society, the state is in a dilemma to identify which is the correct law. Then again, you may find out research areas from your own experiences. Okay, when you are in a situation that you had undergone in a situation where you suffered a lot, or your parents, your relatives suffered a lot because of the negligent acts of doctors, then medical negligence may be a field of your area of interest. Then again, you may be a victim of certain family relations. Then again, you can have an area of research from your experience. If you are interested in the protection, the laws relating to children, if you are interested in certain constitutional or fundamental principles, then you can find out areas focusing on that. You are a person addressing the needs of the society, then you can identify the issues which should be remedied by supplementing law. Then you can find out a framework for that. So the identification of research area depends on various aspects. Okay, your hobbies, your personal interests, your extracurricular activities. So all these things may prompt you to identify a research area of your choice. Then existing theories and the existing research work which had been undertaken by previous scholars, that will also help you to identify the literature, existing literature. Then the examination of the current affairs, political, social, international, linguistic, whatever it be, religious, whatever it be, you can choose a research area from anywhere. Then again, you can use the focus groups. So for example, you have to do upon persons employed in hospitals. You can use that focus groups. If you have to do something for teachers to make a legal framework for unaided teachers in unaided institutions, then you can use that focus group. So the scope or the horizon to identify a research area is unending. And you have to deeply think about the question how you want to get involved in that research, how much you are in touch with, or how much you could be absorbed into that research one. That is most important question. And you have to identify a research gap before proceeding with your research area, your identification of research area. This presupposes wide reading of the literature in the relevant area. Suppose you might be familiar with, or you might be interested in a particular area, and you may think that it's an ideal area for doing something, some research work. But remember that to do research work, legal research in that area, you have to find out the research gap or the literature gap. Identification of some areas that have significant scope for more research. That doesn't mean that it is an area fit for research, because you should be able to identify whether this area been identified and used by previous researchers. And you should be particularly, or you should be sure that no one has picked up or worked on these areas or these ideas. Then you can say that this is a research. So if after reading or after learning most of the research of the literature available in a particular area, if you come to a conclusion that nobody has done some research work, some legal research in this area, and there is a vacuum which should be supplemented by research, or which should be supplemented by certain legal principles, or which should be supplemented by an appropriate or adequate legal framework, then we can say that you have identified a research gap in the area which you found interested previously. In other words, a research gap or a literature gap refers to such unexplored or underexplored areas that have scope for further research. I think it is understood. And how can we identify the literature gap? First, you have to go through the already published literature in the area of interest. Read books, read articles on that area. And see, the area is something which you have interest. Otherwise, it may not be possible. See, first you should have an area, a large area that may be constitutional law, maybe criminal law, maybe family law, maybe administrative law, whatever it be, or surrogacy laws, whatever it be. You have to identify that area of your interest. Then try to understand the existing literature in that area. Read books, articles, journals, etc. This will not only help you understand the depth of the work done by previous researchers, but also will provide an opportunity to ask questions that can help you, that can lead you to a research gap, to the identification of a research gap. So let us see what is meant by review of literature. I used the term review, the expression review. You should review the existing literature. What is it? A piece of academic writing demonstrating knowledge and understanding of the academic literature on a specific topic should be gone through. Simply speaking, you should read the authoritative literature or books or texts or articles available relating to a particular area. It also includes a critical evaluation of certain materials. And this is why it is called a literature review. When you are reading a work, when you are reading a dissertation, or when you are reading a book or an article, you are not simply reading it to get some information, but you are also trying to critically analyze the work to find out a gap, what is left untouched, or to see whether what all things proposed by the author is correct. It's a process of reviewing the literature as well as a form of writing. So that is why you should prepare a review of literature. It is said that you have to prepare, you have to present a review of literature along with the submission of your research proposal. The two main objectives of a literature review are, firstly, the content covering existing research theories and evidence will be made known to the reader. Then secondly, your own critical evaluation and discussions can be supplied to your writing of review of literature. Usually a literature review forms a section or part of a dissertation or research project or long essay. So that can be published by its own review of literature. And it forms part of your synopsis, your dissertation, etc. And however, it can also be set and assessed as a standalone piece. You can publish it, a review of literature on a particular topic. And it summarizes and analyzes previous research, work, theories, findings, etc. It tries to identify the areas of controversy, issues, etc. Then highlights any gaps that may exist in research till date. So this is the content or the meaning of literature review. The basis for reviewing literature is your inherent capacity, your inherent character. Say I told you that it's something genetic, it's something basic as far as a human being is concerned. Always be curious and always question what all things come before you. See, that is the special feature, special character as far as a legal researcher is concerned. The same is applicable. The same will be helpful for you while reviewing literature also. what is the significance of this research to my work or the broader field which I'm having interest? So you should always ask questions. How can this article or dissertation or this thesis work help me formulating my research questions? Then again, does the author's argument require more clarification? Sometimes while reading a judgment, you may have a thinking that, see, this particular reasoning of the judge is not correct. This particular opinion proposed by the author in a book or in an article may not be correct. You may feel so. Then what kind of issues or questions has the author not addressed? Certain areas may be left by the author. Certain areas may be left untouched by the jurors. So you can identify, you can pinpoint it and maybe use it as your research topic. Is there a different perspective that I can consider? What other factors could have influenced the results? Are the methods or procedures used outdated or no longer considered valid in this field? Is there scope for me to test the findings using more modern or current or exact or precise approach? Then you can definitely may seek the help of experienced research supervisors, teachers. You can discuss the issues and problems in your field after going through some amount of literature and discuss with your teachers, then articulating your ideas and knowing what others think and others are working on. And that may help you to identify your study area or even identify mistakes in your approach. If you think a question would be interesting to work on, then you can definitely discuss it with your prospective supervisor and seek suggestions. Now, it's the time to frame research question. I think you by the time you have identified a research gap, it takes some time, sometimes years, sometimes months. That depends on your personality and your capacity, your capability, your intellect, etc. Your background knowledge also. Now it's time to frame the research question. Once you have chosen a research question and set out clear objectives, you begin your journey towards your goal. Even after fixing a research problem, that's sometimes you might have identified a research question or a research problem. See, after undergoing certain amount of research work, you may feel that some other aspects also to be included in your research problem, or some other questions also may be included. That's open always. Still, framing up of research question, that's an important part of your research work before preparing a synopsis. And how to formulate, how can you formulate a research question? That's also interesting. So not that the formulations of a research question is a process, it's definitely a process. It will not end on a single day. It's not something which should be stopped in the beginning. It's a continuous process because your learning, your studies, your research is in the process. And in the same way, along with it, research questions also may be popped up every now and then. And the question may be changed and may be refined as the aims of the study become more targeted. That's why, now the universities require that the synopsis should be prepared at the end of the coursework. The research area should be submitted, a framework should be given, a research proposal should be given. And after 6 months period of time during your coursework, that's conducting or undergoing or undertaking a review of literature, then you should be able to formulate research questions precisely. Your research interest or research area or formulation of the questions, everything will become more targeted at the end of this 6 months period of time. Now, what I have to mention, I wanted to highlight is that preparing research questions, it's a dynamic process. Following some defined steps, but will make the process easier and will help you to formulate your research questions. What are they? Keep in mind that these steps are very general, not specific, not mandatory, but will give you some idea. And depending on that depends on your situation also. The certain steps may be neglected, but may be given attention. First one is try to choose a broad topic initially. Choose an area that interests you as you will be spending a lot of time with it. It's also a good idea to choose a topic that is relevant and lends itself to investigation. Then next step, conduct literature review. That is a mandatory requirement. This will serve two purposes. First, you will find out what research is currently being done in your chosen area. And this review of literature will also show you some potential gaps in the literature that might provide a direction for your research. Unless and until you did a good amount of review of literature, you will not be able to identify the research problems, research gaps, and to set a hypothesis. So reviewing a literature, that will take time definitely. So it's not fair, it's not good to approach a research supervisor with a synopsis and after 2-3 days submitting a synopsis. So that's not good. And then step 3 indicates that you have to narrow down your focus. You should be able to determine some potential research questions. You can use the gaps you found in the previous steps. See, I told you that you should be able to identify the research gaps. Then try to find out your specific area of research. And these gaps you have identified will help you to frame certain potential research questions. So first identify a broad area, then review the literature, some amount of literature in that area, may be able to find out certain research gaps. Then these gaps will help you to frame certain research questions. Okay. Now you should be able to evaluate the potential questions. This is to determine if the question is sound enough or it needs further revision. One common method of evaluating research questions, that is FINER criteria, F-I-N-E-R, the F-I-N-E-R. Each letter indicates an attitude. F denotes feasibility of your questions. The question is well within your ability to investigate. You have the skills and available resources to collect data and complete the research precisely. That indicates feasibility of your research question. Then I, interest, denotes interest. So you should have the interest. The research is interesting not only to you, but also to other researchers and your research community, legal fraternity, your supervisors, etc. Then novelty. N indicates novelty. The research adds knowledge to the field of study, new information. For example, it adds insight or confirms previous work. So now, suppose you are planning to conduct a research on the area of rights of transgenders, or permitting marriage laws, or preparing marriage laws for transgenders. So that may be novel, something novel. But you should be able to identify the previous work, previous research, the development of law, the needs of the society, the attitude of the society, everything should add some insight to your work. Then ethical. The research question and study is one that can be approved by review boards. Say, for example, our doctoral committee or ethics committee and other appropriate authorities. The ethical issues may be examined. You should satisfy the ethical requirements. then relevant. That is very much important. The research question should be relevant to your field of study, and definitely it should be relevant to the needs of the legal fraternity, to the needs of the society at large. And step 5. So then again comes another term, PICO. See, the PICO framework that helps you to properly construct the research question. A strong and effective research question is clear, should be clear. It should be well written. This PICO framework that is commonly used in quantitative studies that may help you formulating a strong research question by ensuring that all the important aspects of a research question is incorporated. So you should be P. You should be able to identify the population, to whom it is focused, whose problems are undertaken, and what are processes which will focus on a particular group, etc., etc. P indicates your intended population, the legal fraternity, the state, or a particular group in the society, whatever it be. Then I indicates intervention, improvement, and investigation. What are the possible solutions by way of your interventions, kind of improvements you can be suggested, and what kind of investigation you propose. Then comparison. C indicates comparison. So maybe the earlier legal system may be compared with the existing, and the needs of the future may be addressed. Okay, comparison in different legal systems. The position in different legal systems may be compared with. Then comes outcome. See, that is very much important. This refers to measuring what worked best. See, the outcome. How will it suits to the needs which you identified in the beginning? Okay, then even while formulating a research questions, there are no specific rules or strategies or steps, even though I had mentioned certain steps or certain strategies. Still, you should be able to identify that there are possibilities for committing certain mistakes. See, that may be drafted in too vague or unclear language. The clarity in language may be missed. Okay. Then the supervisor or your fellow scholars, fellow researchers, or the members in the legal fraternity may not be able to understand the aims of your research. That will lose the scope of your research. Then the question may be too complicated to address in a single study. See, adding too many contents to a single question. And sometimes the opposite may happen. The question is too simple, can be answered by a simple yes or no. And again, the research question is posed in a way that already implies the answer or reflects an opinion. Are you satisfied with it? Yes. Or see, the answer may be indicated by you. And that's not a good question. And the question which is not interesting or relevant, then nobody cares about such questions. Okay, now at this point, you should be able to make out the difference between research question and hypothesis. See, when you approach the doctoral committee for the interview, see, the expert may ask, what is a research question? Or what is your hypothesis? Can you identify the difference between a research question and hypothesis? See, simply speaking, a research question is a question, and the hypothesis is a statement. The research question is the guiding structure, and the hypothesis is the quantification of the research question. The identification of research questions will lead to the hypothesis. So there is a relation between research question and hypothesis. But question will always be in the form of a question, and hypothesis will be in the form of a statement. The hypothesis is a specific statement of what a researcher is trying to prove or disprove. The research question reflects what the researcher is trying to learn. And the meaning of the term hypothesis, an assumption or concession made for the sake of argument. That is the meaning of hypothesis. It can again be termed as an interpretation of a practical situation or a condition taken as the ground for action. A tentative assumption made, hypothesis may be a tentative assumption made in order to draw out and test its consequence. It is not like hypo plus thesis is equal than or less certain than a thesis. It's not the thesis, not the final outcome, but something near to the thesis, less than or less certain than a thesis. We can say again that hypothesis may seem contrary to the real situation. It may prove to be correct or incorrect. Hypotheses need to be clear and precise and capable of being tested. So this can be understood by way of so many examples. Suppose you are a person who is socially interested and you have a quest for justice and you want to do research in a particular area that the social justice has relating to legal aid. You know what is meant by legal aid? That constitutes a person who is not able to financially support his legal proceedings will be assisted by the state in representing before the court to seek legal assistance, etc. And in this regard, you may prepare, you may present a hypothesis that the legal assistance is provided KELSA, Legal Service Society, by way of legal aid, is not adequate. That may be a simple hypothesis. That adequacy may be experimented by way of your quantifications, your empirical studies, etc. But this is a simple thesis. And this thesis, at the end of your research work, this hypothesis may be proved correct. That the legal assistance provided by legal aid machinery mechanism is not adequate. Such a conclusion may be arrived at. But at the same time, the opposite conclusion can also be arrived at. That depends on your studies, your empirical studies, your research work, the interviews, see, whatever it be, you adopt to prove or disprove your hypothesis. And this hypothesis, the nature of this hypothesis should be clear, it should be precise, and it should be capable of being tested. Sometimes your statement may be proved by way of plain interviews or by adopting certain statistical methodologies, conducting empirical studies. Whatever it be, your hypothesis should be clear, it should be precise, and it should be capable of being tested. Again, for example, suppose you have made a hypothesis, a statement that after the coming into force of Juvenile Justice Care and Protection Act 2000, the number of orphan children involved in criminal is very less. The number of orphan children committing criminal activities are very less. This is your hypothesis. It may be proved correct, it may be proved incorrect. Then again, another hypothesis regarding right to education. after the constitutional amendment or after the incorporation of Article 21A in our constitution, almost 90% of the children below 14 years in the state enjoy free and fundamental elementary education. Such a statement may be identified as a hypothesis that can be proved correct or incorrect by way of the research methodology you will adopt. Okay, so many examples. You can cite so many examples relating to your research area. But it is to be limited in scope and should be consistent with known or established facts and should be amenable to testing within the stipulated time. You should provide the stipulated time of your research. And it needs to explain what it claims to explain and should have empirical reference. Always the hypothesis better should be proved with the support of empirical references and studies. Again, let us see that the hypothesis is a clear statement of what is intended to be investigated. It should be specified before research is conducted and openly stated in reporting the results. So this allows to identify the research objectives, to identify the key abstract concepts involved in the research, and also to identify its relationship to both the problem statement and the literature review. So these all are mentioned in various literature, the available literature relating to research methodology. And let us see the nature of hypothesis again. A problem cannot be scientifically solved unless it is reduced to hypothesis. So whenever you have identified a research problem or research question, then you should convert it into the form of a hypothesis, a statement. Then only you can either prove or disprove that statement, that hypothesis. So first frame the question, then convert it into the form of hypothesis, then try to prove or disprove by way of your research work or your empirical work. It's a powerful tool of advancement of knowledge, consistent with existing knowledge and conducive to further inquiry. It can be tested, it can be verified, may be falsified also. And hypotheses are not moral, simply not moral or ethical questions. It's neither too specific nor too general. It's a prediction of consequences. Based on your background knowledge of available literature, your framed questions, your touch with or contact with the existing situations, you have formulated this hypothesis and you conduct relevant study to prove or disprove your hypothesis. So sometimes it may be proved, sometimes it may be disproved. That doesn't undermine the value of a hypothesis, either it's proved or disproved. It's very much valuable even if it's proven false, your hypothesis. Then you might be heard of an expression null hypothesis. So these are used, this term is used, this expression is used when the researcher believes that there is no relationship between two variables that I will explain. Suppose the variable be the number of inmates in a prison. You have to test the result whether the health of the inmates in a prison is taken care of. The number of inmates will be the independent variable. Then whether the healthcare facilities are less or high, that is an independent variable. That's a dependent variable of the number. But If you are a researcher who believes that there is no relationship at all between the number of inmates and the resultant healthcare facilities, how much enormous be the number, there is no issue in providing healthcare facilities in a jail. Okay. Then it can be identified as a null hypothesis. The null hypothesis represents a theory that has been put forward either because it is believed to be true. See, you believe in the truthfulness of the statement. You believe that it shall not be tested. There is no need because the statement which I have given is correct. And you may use this statement for your further studies as the basic argument. And see, this expression, this practice of providing null hypothesis may detrimentally affect the outcome, particularly when there is a relationship between two variables, and you claim that there is no need to examine the relationship between variables. And again, you simply base your research work on this hypothesis which you are given in null form, in nullity. Okay, whatever it be, you just try to understand the meaning of null. Then comes the kind of alternative hypothesis. So this alternative hypothesis is to provide two hypotheses. So one hypothesis is given, and after experimentation, if the first hypothesis proves incorrect, then the second hypothesis may be tested. Normally, in providing a hypothesis, in giving it is opposite. Okay. This is in fact opposite to null hypothesis. Suppose two hypotheses are given, H1 or HA. If the first hypothesis is reached, if HA is rejected, if one hypothesis is rejected. Actually, this alternative hypothesis is the desired conclusion, even if it is not specifically mentioned by the research. Now we have to see the characteristics of a good hypothesis. It should be simple. It should be a simple statement so that it should be easily understood by everyone. Everyone in the relevant discipline in the legal fraternity. And secondly, the hypothesis should be clear, specific, and precise. If the hypothesis is not clear and precise, the inferences drawn on its basis cannot be taken as label. Okay, am I not audible?
Yeah.
Pardon me, am I not audible? Shiba, am I audible?
Ma'am,
Ma'am, you're audible.
Okay, then hypothesis should be capable of being tested. Then it should state the relationship between different variables. The hypothesis should be consistent with most known facts. That is, it must be consistent with a substantial body of established facts. What you said is correct based on the existing facts or legal premises. Hypothesis must explain the facts that gave rise to the need for explanation. It must actually explain what it claims to explain. It should be clear, simply speaking. The hypothesis should be clear. Then now precise a hypothesis. The first and foremost thing is that you should be rich in knowledge. You should be rich in background knowledge. If you are intending to conduct a research in the area of criminal law, you should be a master of law of crimes. Without knowing the fundamentals of criminal legal system, the principles of legality, the jurisprudence behind criminal responsibility, the concept of punishment, etc., etc., you will not be able to frame a hypothesis. So the richness of background knowledge, and again, you should be able to cover the relevant literature in the specific area which you have chosen for research. In the absence of knowledge concerning a subject matter, one can make no well-founded judgment of relevant hypothesis. See, the same is applicable in the case of any stream of or any area or any topic. The background knowledge is essential for perceiving relationships among the variables and to determine what findings other researchers have reported on the problem under study. Suppose you are undertaking a research based on a hypothesis that child marriage is rampant in state of Kerala. Suppose the hypothesis is that the simple statement, child marriage is rampant in the state of Kerala. Then what should be your background knowledge? You should be able to understand who is a child. Who is a child for the purpose of marriage, of child for the purpose of marriage. And why you have framed such a hypothesis regarding child marriage? Is it prohibited? Prohibited by which law? And what are the provisions in the relevant statute? And what about the judicial pronouncements? Is child marriage void or voidable? Okay, the nature, the jurisprudence, the history, the existing legal framework, all those things should be known to you. Then again, there may be certain writings in favor of child marriages, depending on the personal laws. So everything. So I have simply stated a very simple example, which may not be having any relevance, which may not be having any relevance for research, but to understand, for the purpose of understanding the scope of a hypothesis. Then background knowledge is very much essential for perceiving relationships among the variables and to determine what findings other researchers have reported on the problem under study. New knowledge, new discoveries, and new inventions should always form continuity with the already existing body of knowledge. And therefore, it becomes all the more essential to be well versed, well explained with the already existing knowledge. So the hypothesis can be formulated correctly, fairly by persons who have rich experience and academic background and knowledge, but they can never be formulated by those who have poor background knowledge. So always you should be ready to gather knowledge before entering into the stream of research. And secondly, you should have a logical and scientific approach. The formulation of proper hypothesis depends on one's experience and logical insight. Hypothesis does not have a clear-cut and definite theoretical background. See, we cannot say that it should be in this form or in that. Partially, it's a matter of lifting upon an idea on some problem, and it's not always possible to have complete information. But you have to adopt scientific methods for formulating hypotheses, because your hypothesis may be tested and proved by adopting certain statistical methodologies, statistical tools. You adopting statistical tools, which will be given in a separate lecture later. A researcher may begin a study by selecting one of the theories in his own area of interest and then prepare a hypothesis from this theory by logical interpretation, which is possible only when he has a proper understanding of the scientific methods. And definitely he should possess the relevant intellect to utilize these scientific methods. See, the conversations, consultations with colleagues, peers, etc., will add much to the process of developing a hypothesis. Now, let us see what is meant by a research objective. See, this is something which you should be able to identify at the end of your review of literature and forming or preparing or drafting your research questions and even preparing a hypothesis. And the research objective is in fact the goal which you intend to be achieved by way of your research work. That's the end. That's the aim. That is the goal of your research. But this research objective statement is a lengthy written statement which some people used to give it in the beginning itself, because see, the research, the synopsis will be prepared after undergoing this review of literature and assessing the research problems and preparing research hypotheses. And then it is nothing wrong in giving this research objective in the beginning. You may be asked, and it may be the format given to prepare a synopsis. The research objectives that can be categorized into general objectives and specific objectives. So the general objective is a broad explanation of your research. See that what you intend to be, maybe to prepare a legal framework to address the needs of certain categories. Say, for example, you are trying to analyze the enjoyment of right to equality. Then definitely your population will be, you address the needs of you address the rights of women. To what extent right to equality are addressed in our society? Women, male, female, transgenders. Okay. The group to which your issue is addressed. The general objectives may be described in such a fashion. These general objectives are the goals or the aims that should be achieved in the long run or by the end of the whole process of your research work. So they are given in a general format. The general objective may summarize and present the central idea of your study and may describe its purpose. So it entails, you should remember that your general objective entails your hypothesis, your research problems that will be investigated in your research study, and your thematic issue may also be described. Now come to specific objectives. These are in-depth and detailed goals, separate objectives. So a research, your hypothesis may result in certain specific objectives. These are the in-depth goals that have inherent nature of being achieved in the course of undertaking the research. See, in regular intervals or in every now and then. These objectives describe what specifically will be achieved during the study, as the term suggests. So the researcher has to pinpoint the research, these specific objectives. That is very much ideal situation. Along with your general objective, you should be able to state the specific objectives of your research. So far, we were discussing the background based on which you should be able to enter into the realm of research work. First, based on your interest, that interest may be catered by virtue of various factors. So you might have gone through the book of Justice Cardoso on giving a decision on the aspect of judicial process. See, the final result or the judgment may be the result of various factors, the historical factors, sociological factors, the factors of the facts of analogy, etc. So in the same way, your research may be influenced by your interest, research interest may be influenced by various factors. Your passion to law, your passion and interest to a particular area in law. Maybe it is administration of criminal justice. Then again, your focus may be on fixing criminal responsibility upon children and the disadvantaged, or upon certain areas of raising defenses, whatever it be. So from a general area of interest, general branch of law, you are trying to focus your interest on the specific areas, small, precise, definite areas or topics. And with respect to that area, you may have a feeling that there are certain areas untouched by the legal system. And you are about to provide a legal framework, certain principles of law, and you are a person who are addressing the needs of the society, and you have a vision of future, then it is very easy to be plunged into the sea of research. Now the thing which you have to undertake is to review the relevant literature, available literature. You should be a person of learning, a person of intellect, to undertake this review of literature. So you should be able to read a lot, read and read, learn and learn. Okay. Then, not only it's a process of learning or reading, but it's a process of reviewing, questioning, analyzing, criticizing. So both these elements of learning, reading, understanding, narrating, plus analyzing, criticizing, and creating will result in a good review of literature. And while reviewing the available literature on your intended topic, intended area, you may be able to identify certain research gaps where you have to supplement, where you have to provide a framework, where there is a space for your own contribution. Then you can undertake that narrow area as your research topic. Then find out the research problems. That is very much easy because you have in your hand the reviewed literature. And based on that, you have to frame the questions. And we have already mentioned how can we frame good research questions, the features, the characteristics of a good ideal research question. And these research questions will result into a hypothesis, a statement, which the researcher has to either prove or disprove. And based on these research area, review of literature, questions framed, and the hypothesis submitted, and the intended study, you can provide the objectives. In fact, you should be able to identify the objectives at the end of a long process of reviewing literature, identifying your specific core research area, then preparing the synopsis. And the objectives may be stated in general, and it should be accompanied with specific objectives. Now let us see how can we prepare a synopsis. Can anybody share the steps to prepare a synopsis? So that will also be discussed in detail later. Okay, now let me give an example. Okay. The child labor, the instances of child labor in our state should be examined. So a lot of work is done in this area. See, that's not an area fit for research work, but for an illustration, how to prepare a synopsis. The children below 14 years and their right to enjoyment of right to education. This is your area of interest. And the core area which you find after this, after the review of literature is that child labor reduces the scope of education, right, enjoyment of right to education for children below 14. So you are trying to prepare a framework of law to eradicate child labor. So you know that there is a legislation, there is a policy which is adopted by the government. Still, you feel that the existing legal framework is not adequate. According to you, the ideal situation is to totally prohibit child labor at whatever age, below the age of 18 years. A total prohibition is necessary. And based on this premise, you are entering into a research work. See, the topic may be different. See, relation between right to education and child labor. Okay. Then eradication of child labor. Yes, very small topic may be given. And regarding that, whatever be the title which you choose, the synopsis can be prepared, the format. See, let us see. The technical things like the font size, the line spacing, margins, etc., may be given by the concerned institution or concerned school or research center or by the guide. It is varied. But generally, the synopsis may have certain type. First one, the title, the importance of title. It should be, the title should be given. That should in fact reflect. See, how can you put or how can you give a title? It should reflect the objectives of the study. So we are seeing how can you submit, how can you prepare the objectives, the general objectives. It should be reflected from the title. The title should be given in such a fashion. It should be brief, but it should reflect the objectives. And it must be written after the whole synopsis, better, after preparing the whole synopsis. Okay. Then you should give an introduction, should contain the background of the selected topic, your interest, how you identified, and what is the importance, what is the rationale of the study, its relevance. It may contain, it contains the background, rationale, etc., etc. Okay. Now, the objectives. See, while discussing the process of arriving at a synopsis that we have identified regarding the interest, your selection of research area, then research questions, then hypothesis, then we found the objectives. We arrived at a compendium of your objectives. And these objectives which you have found or you have crystallized at the end of your review of literature or your formulation of research questions, your statement in the form of hypothesis, that can be given in the beginning or sometimes at the end. That depends on the school, the format given by the school or by the supervisor. Whatever it be, the objective is an intent of what the researcher wants to do. So I may say that it may be given in the beginning, but it should be stated in clear, measurable terms, simple language. And it may include the need for the study, general, specific objectives. Okay, that we have understood earlier. Now the statement of research problem. The aim, it narrates the aim which you intend to address in your thesis in the form of problems. Now then comes hypothesis. You should definitely state the hypothesis. Then a design of the study should also be included. Design, see, how will the study be undertaken, which are the methodologies may be adopted, the framework of your study. Then the techniques used, the sampling techniques, statistical tools, etc., etc. So that can also be narrated. And those techniques which are narrated in the synopsis should be used later. You should state how it was used. Now comes the most important part of your synopsis. That is the statement regarding the literature, your review of related literature. See, that indicates how much you have studied or how much background knowledge you are possessing, background information. So a research committee, before accepting your synopsis, would look into the review of related literature which you have done. That indicates your background knowledge. And nowadays, in many of the synopses, this portion is omitted. I have wondered many a time, how could it be omitted? So I have narrated the importance of review of related literature as far as research work or preparing a synopsis, whatever it be, is concerned. Then you have to refer the limitations of your study also. Sometimes your theme, your area may relate to a purely secret area which concerns with the security of the state. Then it may not be possible to conduct an empirical study. Available data may not be obtained. So whatever be the limitations which may affect the final result of your study should be specifically provided. And tentative structure of the dissertation for PhD or your thesis, description of chapters, then the whatever system of citation you are using with reference to your, your footnoting and references, blue book citations may be used. So that should be chosen in consultation with your research supervisor. Okay. Then the conclusion with respect to your synopsis. So this is the process in brief relating to your submission of synopsis or relating to your entering into the arena of research. But all the time, what you have to remember is that it's not a matter of compulsion, but it's a matter of interest and basic knowledge. So how much you love law, the legal system, how much you are interested to provide the needs of the society. That will indicate the scope, relevance, and importance and the value of your research work. See, if you are entering into the area of research just for the sake of obtaining a job or to fix a doctor before your name, or to follow the model of your peers, whatever it be, that may not do justice to legal research. Okay, now I think you might have obtained certain ideas, certain basic ideas regarding the process of entering into the arena of research. So I have just mentioned what is a research objective, how to formulate research questions, what is a hypothesis, and also how to prepare a model synopsis. So if you are able to address certain topics or certain areas, let us see how can we prepare these things. And I hope you have understood at least a little. Do you have any doubts or queries? Then only I can give a detailed description of your needs, depending on your needs. Will you please raise your questions or put your questions?
Okay,
Or
thank
even
you,
put your suggestions?
Jasmine, madam. The participants can put their questions in the chat box. Ma'am,
Yes.
ma'am, can you open the chat box, or else I will read the questions?
Okay, okay. Better you read it.
Okay, okay, ma'am. There is a question from Saumi Roy. While formulating a research proposal, do we need to write both the general objectives and the specific objective?
Okay. So if you are supposed to give general objectives and specific objectives. That indicates the depth of your background study. So I have told you that you should undertake adequate review of literature, taking some time. That may take even 1 or 2 years, or sometimes months. That depends on your need. Still, the statement of your objectives, both general and specific objectives, that is indicative of your background knowledge, how much review of literature you have done. Okay. So it's ideal to give general and specific objectives, according to me. Okay.
Ma'am, the next query is, can you give an example of a research question?
Okay, so that I have mentioned research question. So when suppose the area of research is the critical analysis of right of children for free and compulsory education act in the state of Kerala, the application of. And the research objective may be, the general objective may be to conduct a study on the enforcement of the provisions of this particular act. The specific objective may be to identify the education provided in the state of Kerala below the age of 14 years in different schools, let's say in the state stream or in the unaided stream. So specific objectives may be provided. Then again, another objective may be to identify the impact of child labor upon education, right to education of children. Maybe the impact of broken families upon the enjoyment of right to education, maybe specific objectives. And before arriving at objectives, I have told you that first you have to frame questions. Okay. Is there any lacunae in enjoying right to education in favor of children below the age of 14 years because of child labor? Okay, that's a question. Then again, another question, whether broken families result in lesser enjoyment of right to education for children. Then again, poverty. Is there any influence of poverty upon the enjoyment of such and such kind of questions? Okay, you're asking me to give examples of questions. Then these questions may in the next stage be stated in the form of hypothesis also. Poverty, broken families, child labor will result in poor enjoyment of right to education of children under Right of Children for Free and Compulsory Education Act. This is an example. Okay. Now this hypothesis may be proved or disproved by way of empirical research. So you can conduct empirical studies. Okay, then next.
Ma'am, when to write a literature review for our synopsis, what all are to be stated, and are we supposed to state all the important literature that we have gone through?
Definitely. You have to mention all the important literature, available literature in that relevant area, but it may not be possible within a short span of time, but as much as possible. The authoritative texts, so that the cases you have undergone, everything. So it indicates the depth of your background knowledge, how much you have studied, how much you are familiar with the stream of law, how much knowledge you have acquired regarding the area of your research. Okay. It's more better if you read a lot, if you have collected information as much as possible. You cannot limit the scope of literature review and as well as the content of literature review. Yes.
And is hypothesis an improvement of research question? The question from Uma Maheshwari.
Improvement can be termed so. And moreover, I do want to say that the research questions will help you to formulate your hypothesis. So it's a compendium of, you may have 4 or 5 questions. It's a compendium in the form of a statement of your research questions. If you have a single research question, then definitely that research question converted into a statement gives the hypothesis. That depends on situation. Okay. Anyway, the formulation of research questions will lead to the statement in the form of a hypothesis. That's in the form of a statement. Definitely the research questions will be reflected in hypothesis. Okay.
Miss, there is a question from Pratyusha Mukherjee. What is the difference between research problem and research question?
Okay. Research problem is, first of all, you should understand that research problem, these terminologies, research problem and research question are interchangeably used. But certain researchers or certain jurisdictions, they use research problem that highlights mainly the research gaps, the research problem, the area into which you have to do research. And otherwise, research questions, that is indicative of the questions or the specific questions or the specific issues which would highlight this problem. That can be termed in this fashion. But remember that research problem and research question are interchangeably used. If you see in such a fashion, then don't feel bad. Okay.
Ma'am, the next question is how to choose the right method of research?
Can you explain that question once again?
How to choose the right method of research?
Method indicates what? The person who
It's a question from Pratyusha Mukherjee.
Yes.
Can you
method?
Pratyusha Mukherjee, can you explain it in detail?
Yes. Pratyusha, what do you mean by these methods? We cannot specifically provide a simple method. It's a compendium of all the methods which I have mentioned earlier. So, a doctrinal research, a doctrinal method alone cannot be considered as an ideal method. So, a research which may have its objectives, which can be derived by way of empirical alone, or adopting interview method alone, or a research which is based on narrations alone, or fundamental or primary analysis. So it's a compendium that I have mentioned in the beginning itself. If the person who asked the question, if you are able to explain what you intended, see, all these methods and methodologies, a compendium of methods, the selection of which is based on the area of your research. Sometimes that can be purely doctrinal. That is based on, if it is the interpretation or explanation of certain juristic concepts, certain jurisprudential ideas, then there is no need of empirical work. That depends on your area. You cannot say that this is ideal, that is not good. Still, many a time, different methods as well as methodologies should be adopted. Okay, then Pratyusha Mukherjee, are you satisfied?
Yes, ma'am. Actually, I wanted to ask you, like, in conducting a research, first of all, we after choosing a particular research problem, we have to adopt a particular method in which we can conduct our research. But
Yes.
at the time of doing research, like, we have to adopt different methods as well at the same time.
Yes, because your knowledge, information, background knowledge, etc., are very much limited. So, in the course of your research work, or as your research study progresses, you can add the methodologies depending on your knowledge, information, and requirements. Okay.
Yes, ma'am. That's why. That's
Yes,
it.
yes.
Like, thank you so much, ma'am.
Yes. Okay, then anything else?
No, ma'am. Any further questions? I think we can conclude the question answer section.
Okay. And I'm very much thankful to meet you, the prospective researchers and eminent academicians. Okay, thank you for giving me an opportunity.
Thank you, Jasmine madam, for the wonderful class. Before ending the section, on behalf of LSL Law College, I would extend my...
Pardon me, one more question. What is the way of writing literature review? Did you see that question? Last
yes,
question.
yes, yes.
Will you please read it aloud?
So it's a question from Saumi Roy. What is the way of writing a literature review?
Okay, there is no specific way of writing literature review. We cannot say that this is the format, this is the scientific format. But generally, it should highlight the content which you have gathered. And along with it, you should mention the references. So the source, maybe juristic opinions, maybe certain reports, or maybe certain judicial pronouncements, or the source from which you have gathered that information, that basic information. So anyway, it should indicate how much background knowledge you have informed. And you may even give a description that a particular author describes this thing, this principle in this fashion, and I am not of the view. And I have a disregard. That kind of comments and criticisms also can be included. And sometimes it may be in the form of a critical analysis, or maybe writing an article with your own personal contents and comments. Okay. That's why I have told you that this review of literature may be published separately as a piece of your writing or your publication. Okay. That will have that much of value. So that depends on your wisdom, your skill of writing, articulation, listening also. Yes.
Any questions?
Yes. Anybody else? So I'm very happy to receive your questions, accommodate your queries. Okay, anyway, I'm very much thankful that the session is feels very attentive and interactive. Thank you for your patient participation.
Surya, you may conclude.
Okay. On behalf of LSL Law College, I would like to extend my heartfelt gratitude to Dr. Jasmine Madam for accepting our invitation and for being a part of this program. Then I would like to convey my thanks to Dr. Lovely Powers, our principal, for her guidance and support. Then I thanks to all the participants for being a part of this program and for making it a success. Finally, I would like to thank faculty conveners, organizing committee members, and students for their work and support to make this program a grand success. Thank you. Thank you, one and all present here.
Thank you, Jasmine ma'am, for your
Thank you. Welcome.
Okay, ma'am. For your
Will I leave?
Okay, our section is over and we by 1:30 p.m. the third section. Thank you, all the participants who are presented over here, and you can leave now. Thank you, ma'am. Thank you.
Yes.